I've spoken to quite a lot of people on this side of the pond around UPC, both in continental Europe and in the UK, and their views. But it would be really good just to understand what the sort of US view, what you're seeing within the firm, within your client base, as to the view of the UPC. Are people excited, skeptical? Are people going to engage with it? Because for Europe, it's going to be a sea change for patent litigation. And it would be good to just understand, how that's viewed more broadly than in Europe.
I think we get two different types of responses. From clients, we hear interest. We see folks who want to learn more about what it means going forward. We don't see necessarily excitement yet with purely domestic clients, but there's a lot of questions, some of which are being answered at the moment by EU firms doing sort of roadshows in the US to educate the client base here and bring them up to speed as to what this could potentially mean in the years to come. What we do see, however, is enormous interest from litigation funders who see this as a sort of, brand new open world, brand new set of opportunities here, if indeed the UPC turns out to live up to its potential. So a lot of appetite there as to what it means, how it's going to change the litigation funding world, how it's going to open essentially a new arena, a new sandbox in which to play for funders. And I think what we're hearing, and I said 2 categories, I'm going to amend that to 3 categories. What we're hearing also from EU firms with whom we work a lot is question marks. They know what it says on paper. They know what the UPC is supposed to be. They know what they've been promised. They also know they've been promised other things from the UPC, such as a launch date that turned out to not be entirely accurate. So they are waiting to see how quick it's actually going to be, whether there are going to be, material differences in the jurisprudence emerging from each different center, how long it's going to take for the court to really run smoothly, because we can imagine in the first 6 months there are going to be some hiccups. So how long it's going to take for really the court to hit stride, and a lot of question marks as to who among their client base is going to be willing to dip their toe in first, with taking the risk of going into an unknown jurisdiction, but also potentially taking advantage of the opportunity to shape the narrative and to shape the jurisprudence with a good test case, and really lay the groundwork for some good jurisprudence down the line. So that was a very, very short question, very long answer. Hopefully that addressed your point.
Yeah, I think that was great. I think from the litigation funding side, we see, obviously the market will be broader, but that's going to very much depend on how widely firms or companies have validated their patents now under the EP system. So until the unitary patent becomes a reality, it may be sort of a case-by-case basis as to whether there is real sort of difference in size of damage award by comparison with, going after an individual action in one sort of jurisdiction. So I think the question is, do you see different market sectors or different industries having a different view of the UPC and being willing to dip their toe in the market first? Or do you see sort of a general trend of sort of wait and see?
So it seems like the main divide will be between the tech or high tech industries and the pharma industry. And I think one thing that those industries will have to consider is the layout of their portfolios. It seems that in the pharma industry, you may have a smaller set of patents or maybe one patent that really controls the market and really is the leader for a product. And so it may be riskier to try to put that patent through the UPC. Whereas I think with a lot of the tech industry and a lot of those patents, you see much broader portfolios. And so maybe you can take some more risks there. I think there's also going to be a consideration with the value of the injunctive relief that you can get from the UPC as well. And it seems that in the pharma market, that actually may be a lot more valuable since every day matters when a new product is about to hit the market. I think that in the tech industry, injunctions are also valued, but there is probably also more premium on damages as well. And that's one thing that we in the US are really interested in seeing as well, which is how the availability of injunctive relief will be different at the UPC we expect that it'll still be easier to achieve injunctive relief in the UPC than it is. As you know, Emily, I'm sure it's very, very difficult to get injunctions in the US due to the eBay decision. And a lot of parties are turning to the International Trade Commission to get what is basically the equivalent of injunctive relief, an exclusion order. That's a very costly and also very difficult type of proceeding. So it'll be interesting to see how injunctions play out at the UPC. Then I think that'll also spur different industries to move into the UPC based on how that's.
I think that's exactly right. And I think I would add also, I wonder whether you're going to see, even within some industries, let's say within the pharma industry, or within the biotech industry generally, a greater awareness of how you could potentially use the UPC to fashion jurisprudence in a way that is sort of more beneficial to your industry or your area of work than maybe some of the national jurisprudence might be. For example, Google, for most of its activities and for most of its patents, may not see a huge benefit in trying to mold the jurisprudence of the UPC. But a pharma company with like a significant biotech or DNA editing division may see some benefit to really laying the groundwork, or really maybe trying to reverse what it sees as less than beneficial precedent in the national jurisdictions, and trying to really reshape the narrative at the UPC level in a way that's going to protect its industry for in the long term.
I think that's interesting. I mean, so quite a lot of the judges in the UPC are current national judges. Obviously, they will be operating under new rules and in a new forum. How much do you think they will bring in their kind of national flavour into the UPC? And how much do you think that they will be able to achieve harmonisation across the different national and central divisions, or local and central divisions?
That's a great question. And Jonathan, jump in if you disagree. The answer to that question is going to be very jurisdiction specific, because depending on the country of origin of these jurists, they may or may not have prior specialization. Or even if they do have specialization, it may have been like just a few years of specialization. Whereas in some jurisdictions, some of these folks will have done 30 years of IP law, others will have just done a stint in an IP-focused chamber for 3 years, simply because in that national system, they tend to rotate through. I think the propensity to bring in prior national practices into the UPC jurisprudence is probably going to hinge a lot on whether these jurists fall into one of those buckets or the other. That's my impression. Jonathan, do you see this differently?
I agree with that purview. The other thing I'll add is that, as we like to say, old habits die hard. So if you've been practicing under one system and you've been dealing with those nuances when it comes to damages, injunctive relief, validity issues, infringement issues, whether you come from a jurisdiction that's more plaintiff friendly or more defendant friendly or friendlier towards different industries, it's going to take some time to let go of that for sure, especially with a new court like the UPC. So I think what that could mean is that we start off in the UPC with quite a few slightly divergent views, and it may take some time for the judges to coalesce around some common principles and understandings. And I suppose that's to be expected with any new court system, even if you have a bunch of brand new judges. And maybe there's really no better outcome here or better approach here, because if you start off with a bunch of brand new judges, then you're starting from scratch and they don't have the prior experience that they can leverage. If you do start with judges with previous experience, that's obviously very, very valuable. And I think that'll be an advantage here, because it does seem that litigants will want to hit their ground running with the UPC and expect judges to really be experienced and know how to shepherd patent litigation through the court system.
So I think a lot of the judges, particularly the German judges, are already infringement court judges, and other judges will have had some IP experience. Being a bit controversial, do you think that the UPC could really compete with the US fora in terms of having, you've mentioned the injunction possibility, but also specialist judges deciding cases rather than general judges and potentially jury deciding cases as the court develops?
I'm not sure, and perhaps we're naive about this, but I'm not sure we see this necessarily as a competing venue. I think for much of our client base, it's just an extra front, and it's new opportunities and an extra lever on which to pull in litigation, both on on the plaintiff side, but also on the defense side in some cases, or as an avenue for potential counterclaims. I don't see this necessarily as a replacement jurisdiction, because I think it's a little bit apples and oranges. What makes the U.S. system what it is not only it's not necessarily specialized judges, although in certain jurisdictions that does help, right? To have folks, district court judges who've done hundreds of cases, it's beneficial. But I think what makes it special is the jury system and the numbers that can come out of that, the damages numbers that can come out of that system. It remains to be seen whether the UPC could generate that kind of numbers, even if it operates the way it potentially could, right? Even considering the number of jurisdictions and the markets, the size of the markets involved, it's not yet clear that you're going to get to see the same numbers as you see in the US. So there's a lot of ways in which it's likely to be a very useful tool, and a tool in which you're going to benefit greatly from having specialized judges. I'm not sure in terms of getting huge damages on the back end whether it's necessarily going to be a substitute jurisdiction. Jonathan, does that resonate with you?
That resonates with me for sure. And to add on to that, I totally agree that at least right now, the UPC won't be an alternative or a substitute for the US court system, particularly for US-based companies. Part of that is just bias. Part of it may be that their largest markets are within the US. But I also think that the UPC will be seen more as a complement to the US court system, maybe in the same way that the International Trade Commission is seen as a complement to litigation and US district courts. And that means that it can still become a very, very powerful tool for patent holders, inventors, innovators, and plaintiffs to wield, and can definitely become a more significant part of US-based litigation strategies than what we've seen so far. Because in my experience, if you're working with a US-based client that's primarily focused on litigating in US courts, then you weren't really thinking about litigating in Europe. Obviously, the litigation would be broken up in Europe. And then there are some logistical difficulties as far as finding the proper European counsel, having those relationships established, so on and so forth. And so the UPC will probably ease the way for US litigants to incorporate a European component into their litigation. And then as far as whether it'll make a difference that there are specialized judges who have worked on courts that focus on patent litigation, I think the US perspective on that is a little bit mixed. So obviously we have a split court system where we have some generalist judges hearing patent cases, but then we have some specialist judges hearing patent cases too. At the federal circuit, our Court of Appeals for patent litigation matters, at the International Trade Commission, and then also at the Patent Trial and Appeal Board. And what's been interesting is seeing the Patent Trial and Appeal Board, PTAB, evolve over the last 10 years. And when you look at that at first glance, you might say, great, you have all these PTAB judges who were patent practitioners litigating some of the toughest patent cases across the country or across the globe. That's great. They may be more informed and better able to reach the right decisions than a generalist judge. But I think what we've seen over the last 10 years of the PTAB is that that's not always the case. And so I don't think that some US litigators and some US litigants put such a high premium on a judge having prior patent litigation experience. And in some ways, I think for some litigants, that can be a disadvantage because you may not want a judge that's too locked into some of the technical nuances of the case that might cause them to miss out on some of the larger, bigger picture issues, especially when those issues apply to the amount of damages that you might be able to recover or whether you can get injunctive relief. Ben and I are the type of patent litigators where we love to tell a good story. And a good story is, of course, attached to the technology and other fine details, but it's also attached to something that sometimes generalist judges are better able to relate to, or a jury is better able to relate to. And so there is a bit of a risk with going into a more specialized court that you lose out on some of that advantage that comes from telling a narrative.
I think that's super interesting. So the specialist technical judges may miss out on the context of the invention to the general population. I hadn't really thought about that before, so I think that's interesting. Just picking up on your PTAB point, do you think that the coming in with the PTAB and IPR and the length of time and that takes could be a sort of a threat to the nullity proceedings in the UPC?
My impression, talking to firms, sister firms in France in particular, and in the EU in general, is that no, there is not the perception that the IPR system is going to hamstring the UPC in any way. If the timelines that are under consideration seem similar enough that one will not necessarily be seen as eating the lunch of the other. But that's just very anecdotal. My impression is that there's no real fear on the part of the bar in the EU right now about the IPR being seen as a competing path. Jonathan, are you hearing differently?
No, I haven't heard anything differently. I think from the US perspective, if anything, the PTAB and IPRs may push some people to move into the UPC and try to use that as a better litigation forum, just because plaintiffs are so adverse to litigating PTAB and IPRs. And so in some sense, maybe that'll be seen as a better way to hash validity issues.
Emily, I'm sorry if I'm taking this all on a tangent, but for me, one of the interesting aspects of the speed of the UPC, assuming it goes as promised, right? Assuming it is fast as promised, it's not only, obviously it's interesting to see what it means for the clients. It's interesting to mean what it means for the funders. It's also very interesting to see what it's going to mean for the patent bars in the various jurisdictions in which this is operating, right? Because there's a very real possibility that you're going to see a fragmentation of the market between firms that are going to focus only on national proceedings and firms that are going to focus on the UPC, knowing that in many of these jurisdictions, what has been, the traditional IP boutiques may simply not have the headcount to handle, two UPC matters at the same time involving 8 patents each. You're going to need a certain size, just like you do, you need a certain size patent group in the US to handle multiple ITC matters, given the speed at which they operate and given how much work needs to be done in a compressed amount of time. It's going to be interesting to see for example, in France, but in other jurisdictions too, like whether you see a shakeup in the legal market with some folks deciding they're going to commit to the UPC and sort of bolstering their ranks and making sure they have enough line attorneys available to handle these big matters going forward at high speed, and those saying, you know what, we're going to be a 5-person shop. We're going to remain a 5-person shop. We're going to focus on national level proceedings. We're going to focus on smaller and medium-sized enterprises that have less to gain from a UPC procedure, and that's going to be our market going forward.
That's a really interesting point. And I think from a UK perspective, following Brexit, we have seen a number of UK firms who were UK only opening European offices so that they can take part in the UPC and represent clients there. I think it's also a question as to who is going to be the people representing the clients in the UPC. So traditionally, there's a split between sort of litigators who have litigated at the national court level and patent attorneys who have, litigated in the European Patent Office and provided some technical support in some jurisdictions like Germany for litigation. But both sets of lawyers will have standing to represent clients in the UPC. And I think it'll be interesting to see whether the patent attorney firms move that forward and are running litigation matters themselves. So there could be more competition in the market more generally, I think. Whether the current setup will enable firms to service both jurisdictions, I think will depend on how cases run in the nationality. So it could already be that firms are set up for sort of the bigger cases and bigger proceedings. From a UK perspective, I think the streamlining of the decision and the actual hearing means that actually sort of on supporting a case may be lighter in the UPC than in the UK courts, because disclosure is going to be more limited, witness statements are going to be more limited. It's going to have quite a sort of continental feel in terms of, short one-day hearings rather than, days or weeks of hearings that we're used to, and sort of live cross-examination as we're more used to in the UK and the US. So I think it's interesting, and I'm going to ask some of the European firms as to how they're seeing that, because I haven't done that. So that's a really good question. You mentioned one group that's really interested in the UPC is funders. Obviously, we're watching with interest. From our side, I think it will depend on who's in and how widely their patents are validated, how strong their patents are. Are organisations putting in their strong patents, or is this going to be a second-rate court with just the weaker patents being used as test cases? Also, how will the rules be applied? Given that the US funding industry is primarily US focused, how are they viewing, moving into Europe and a court that has much more of a civil law flavour?
My impression, and Jonathan will chime in if he's hearing differently. My impression is that, yes, of course, that there's some question marks as to how it's going to operate and what kind of patents are going to be asserted first. But mostly there is a huge appetite because, as you know, I'm not telling you anything you don't know. You know this far better than I do. There are enormous amounts of money waiting to be deployed in the US. There's potentially, and my litigation funder friends will not want to hear this, but there's potentially more money than can be really effectively put to work in individual cases sometimes. So there's enormous pressure to find outlets for this money. And in the US, there's plenty of cases, but maybe, there's also a lot of funders fighting over a limited number, universe of cases. This is just a brave new world of new opportunity, not only for new cases, but also it also offers new opportunities for acquisition of portfolios. Suddenly, a lot of these companies or universities that had sort of very EU-heavy portfolios with a few other patents elsewhere that were not that interesting to patent owners or funders or everything in between are suddenly available, potentially still relatively cheap and ready to be exploited. And so it opens up all these new doors for funders to use their money to deploy their money in a productive manner. So it's not only litigation, but also sort of new assets becoming available and having new potential value assigned to them. Jonathan, is that a fair view?
That's definitely a fair view. One thing I've noticed over the last few years is that it seems that quite a few funders have already integrated foreign jurisdictions into their strategies and their campaigns. And it seems that some individuals have actually been preferring some foreign jurisdictions over the US because over the last few years, there's been a growing dissatisfaction with changes in US litigation, including with the PTAB and IPRs, with Section 101 and subject matter eligibility issues. And so I think funders and plaintiffs and patent holders have been looking for jurisdictions outside of the US and looking for that complement or that alternative in some respects. And so I think there will continue to be growing interest. And I think one of the bigger challenges is just sort of figuring out how to coordinate whatever the UPC becomes with how the US court system is changing and what some of the current funding strategies are. For instance, will patent campaigns going forward pretty much look the same and just dabble a little bit in the UPC when it's helpful, or will there be actually a paradigm shift in how patent campaigns are run, where maybe you have some campaigns that are largely focused on the UPC with a US component or vice versa? So I think that's yet to be seen, and it'll depend on all the variables and factors that we've been seeing so far.
I guess it'll depend on a case-by-case basis and on the sort of facts and the qualities of the case, because if there's a possibility for willfulness and a triple damages, that's something that's not available in the UPC. And I think, that's a big attraction for funders and, for people to litigate in the US. The points you made around the sort of secondary patent market and there becoming more interest in the European part of portfolios is quite interesting. That we see portfolios presented to us regularly. We have never acquired a portfolio because we don't have the bandwidth to litigate and manage that. But do you see the UPC becoming what is now maybe a Western District of Texas type jurisdiction that's quite favourable for NPEs, whereby it's a quick forum that is maybe plaintiff friendly?
I hesitate to give a clear-cut answer on this. It has every opportunity to be that, or like something like that. The pieces are in place, and if everything runs according to plan, it could be something like the Western District of Texas. Not exactly, obviously it's slightly different. It will have some advantages that WD Tex does not have. It will have some, and the WD Tex will have some advantages of its own. But it has the potential to be that. But there's what we are hearing from all our counterparts in EU firms is still a lot of uncertainty, and folks being really reluctant to make any predictions as to how it's going to run. There's just a lot of question marks. So we hear a lot of folks doing roadshows and giving presentations about how it's supposed to run and what the rules say, but as to how it's actually going to run, whether these timelines are likely, whether you're going to see too many heterogeneous decisions or inconsistent opinions coming out of various centers, thus sort of jeopardizing the value of the system as a whole, are questions that are still very much top of mind for our counterparts. So I don't know that Jonathan, correct me if I'm wrong, but I don't know that we necessarily know. We're keeping an eye on it. We're super interested in it. We just don't know that it will necessarily live up to its potential.
I totally agree with that. We just don't know. I would say that we hope that it does live up to its potential. The promised speed of the UPC is one of its greatest attributes. And I think that will make it attractive for some of the same reasons that the Western District of Texas is attractive. But it's yet to be seen for sure.
I think that's right. I mean, it is uncertain. We don't know how the judges are going to decide or apply the rules. And it's going to be a range of different judges, unlike to date in the Western District of Texas, where there has been that sort of consistency. I think from the litigation funding side, it's also difficult when you're trying to risk assess a case, because in the US, there's lots of data around, the judges, the jurisdiction, how cases sort of are decided there, how cases are approached, what the real timescale will be, because another aspect of the UPC is that could be bifurcation. So if the German judges want to sort of follow their sort of national routes, they may well bifurcate the nullity from the infringement case, and then it's not going to be a 1 year process. So I think there is that level of uncertainty for sure. Do you think that uncertainty together with adverse party cost risk is going to put claimants off from litigating in the UPC? Because to date, in continental Europe and in the US, there's no real cost shifting. There is a regime in Germany, but it's quite low in terms of the statutory fees that have to be paid by the losing party. But the UPC is bringing adverse party costs up to more of a kind of UK level, which will then maybe be a deterrent for some plaintiffs to bring a case, or be a new sort of aspect that they maybe haven't considered before if they've litigated in the US or elsewhere where there is no real cost shifting. Are you seeing any sort of hesitancy from that side?
My impression on the second component of your question regarding the cost shifting, I wonder whether plaintiffs will obviously will be aware of that risk, but will set up entities such that they are effectively judgment proof in the event of a cost shifting ruling. I don't know whether that would pass muster under EU law and whether it would be tolerated by the courts. But that's my first thought. Like, I suspect folks will be trying that to sort of diffuse the risk of a fees judgment. Does that make sense?
It depends, I think. So in the UK, we have a security for cost provision. So if the entity is a straw man, then the defendant can make an application for security for costs, whereby the defendant needs to pay, or the claimant needs to pay into court a sufficient amount to cover the costs, or to obtain insurance. And I think the insurance market at the moment, from what we see, is very UK centric, so very London focused. So for litigation that is happening that has no UK nexus, the market is a lot narrower for insurance. So continental litigation or non-UK parties, and there are fewer players in that market at the moment. So I think we're going to see a growth in the insurance market to cover those types of cases.
Do you think that kind of system is generally representative of the baseline across the EU, or is that an outlier?
It's an outlier. So generally, there's no cost shifting or very minimal. So Germany, the cost shifting is based on a statutory scale, so it's a lot lower than actual costs that would be incurred on a sort of an hourly rate billing type setup. But we're obviously quite used to that from the UK side, because we have often 70% of costs are awarded.
We have a few questions for you. So one question I have for you, Emily, is what you want the UPC to be, because we don't know what it's going to be. It could go in a lot of different directions, and the direction that the UPC takes will partially depend on the judges and their jurisprudence. But I was just thinking that it's also going to depend on the litigants and how they help the judges to shape the path of the UPC. So if you could forecast what the UPC looks like in 10 years, what would you want it to?
So I think for me, what would be an ideal court, if the UPC could turn into that, would be a jurisdiction which has predictability. So fast decisions and predictable decisions. So consistency between the local and central divisions and between different jurisdictions. Consistency not just in sort of procedure, so bifurcating or not bifurcating, but also in terms of damages awards and approach to sort of case management. I think one thing which is a benefit in the new court is that in every single jurisdiction, English is an alternative language. So for most organisations, it's really helpful for them. So if they need to go and litigate in France, it takes away some of the cost and the difficulty of managing a case that has to have everything translated into the local language. So I think that's definitely a plus. I think having a real sort of adverse party cost regime means that hopefully the cases that we brought will be good quality cases. So we would ideally like to see good quality decisions. So, having organisations, engage with the court system and shape the court system with good quality assets is also very important from our side. So not a second-rate court or a test case court, but an actual real sort of court that people engage with and take seriously. And I think when the unitary patent comes into force, if organisations validate in Europe more broadly than 3 jurisdictions, then designating unitary patents in the transitional period rather than individually validating will also mean that the damages may be higher across the jurisdiction. So I think there's a lot to be excited about, but it just depends on whether we do get that ideal court or whether it goes in a different way.
And then another question I have is whether the UPC has already had a strong effect on your funding strategies, or whether you guys are still waiting to see how things develop, or you change the way that you fund cases, or you seek out potential plaintiffs and patent holders and things of that sort, and even how you coordinate, with your US efforts.
I think we assess cases in the same way. So we're still looking at the merits. It's got to be a good case, and we're still looking at the economics. It needs to make sense from a funding perspective. So we don't invest in any case where the claimant doesn't come away with the lion's share of the damages. So it still needs to make sense from that perspective. But I think the sort of broadening out into the UPC can make cases which on a single jurisdiction were not sort of economically more viable. And we looked at a portfolio from a company who had validated quite widely within Europe, and the infringer was infringing in a number of different jurisdictions, potentially manufacturing. And so the UPC would have kind of swept up all of that activity in one jurisdiction rather than having to sort of fund in a number of different jurisdictions. So I think from that perspective, it's, as Ben said, it could be an additional kind of string to the bow in terms of strategy and looking at cases. How it would coordinate with the US action? Well, I think, the US still has the triple damages and it's an established court system. So, looking at sort of comparing jurisdictions and, where to start and how to put the strategy together, I think it will depend on the profile of the portfolio, the company, the type of technology. Maybe, software is maybe higher risk in the US. Perhaps the UPC might be a more consistent jurisdiction at the moment. But there's no case law yet that we can look at. So I think it's going to be an additional consideration, but I mean, we will still look at the same factors that we look at for all cases when we're looking to fund. So strong case, good economics, claimant that's engaged, defendant that can pay, and a law firm that understands the jurisdiction and is proactive. The UPC is going to be a sea change in litigation for Europe. Are you excited about it? And what do you think is going to be the key positives of the court?
From the outside looking in, as US practitioners, we see this as a potential additional forum for many of our clients, a forum with enormous potential, a forum that opens up a lot of opportunities for them, but also a forum with a lot of question marks. So we're looking at it closely. We think it can be, if it lives up to expectations, it can present spectacular opportunities for us and for our clients. But there still remain many questions that are going to be answered, we suspect, in the next year and a half as the first few cases make their way through the process. So very interesting, lots of opportunity. We're keeping a close eye on it, but we still have some questions.
We're very curious to see what happens and very excited and very hopeful. And we're definitely looking to get involved with the UPC when we can, both with our US-based clients and our foreign clients as well. And hopefully trying to use the UPC as a complement to US litigation, especially with some of the downsides of US litigation, including IPRs at the Patent Trial and Appeal Board and issues with subject matter eligibility under 101. This will be a new bright light full of potential for the patent litigation world. I think this is also really, really important just with the general trend and the globalization of litigation and patent campaigns. We've seen more patent disputes be arbitrated internationally. And so this, I think, will make it easier for litigants to pursue and enforce their portfolios across the globe.